Section 191 of the Bharatiya Nyaya Samhita, subsection 1 provides, whenever force or violence is used by an unlawful assembly or by any members thereof in prosecution of the common object of such assembly, every member of such assembly is guilty of the offence of rioting. Subsection 2 of section 191 provides, whoever is guilty of rioting shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Subsection 3 provides, whoever is guilty of rioting, being armed with a deadly weapon or with anything which used as a weapon of offence is likely to cause death, shall be punished with imprisonment of either description for a term which may extend to 5 years or with fine or with both. In a nutshell, it can be said that when the violence or force is used by any member of an unlawful assembly or by members of unlawful assembly, then that becomes a rioting. Section 191, subsection 1 of the Bharatiya Nyaya Samhita correspond to section 146 of the Indian Penal Code. Section 191, subsection 2 of the BNS correspond to section 147 of the Indian Penal Code. Section 191, subsection 3 of Bharatiya Nyaya Samhita correspond to section 148 of the Indian Penal Code. And a very important thing, a legislative change has been taken place, that is, imprisonment period has been increased from 3 years to 5 years under section 191, subsection 3 of the Bharatiya Nyaya Samhita. Section 191, subsection 1 provides, a riot is simply an unlawful assembly in a particular state of activity. That activity being accompanied by the use of force or violence. It is only the use of the force that distinguished rioting from an unlawful assembly. The word riot is a term of art, and to popular belief, a riot may involve no noise or disturbance of the neighbors, though there must be some force or violence. Section 191, subsection 1 provides a definition of rioting, and punishment for the same is provided under section 191, subsection 2 of the Bharatiya Nyaya Samhita. Meaning of force or violence. What is force or violence? Force is defined in section 128 of the Bharatiya Nyaya Samhita, and it has been used here in that sense. It is restricted to force used against persons only. Violence is not restricted to force used against persons only, but extends also to force against inanimate object. Thus, violence is wider than force because it includes force used against property and other inanimate object. Even the slightest use of force by any member of an unlawful assembly, if proved to be unlawful, constitute rioting. But force must have been used in prosecution of the common object of the assembly. We have seen the common object. The mere use of force by a number of men assembled does not render all of them liable for rioting. The essence of the offense lies in the use of force to achieve common purpose. If the common object of an assembly is not illegal, it is not rioting, even if a force is used by any member of that assembly. The sudden quarrel. If a number of persons assembled for any lawful purpose suddenly quarrel without any previous intention or design, they would not be liable for rioting. Further, it is not a riot for a member of the audience in a public theatre to applaud or hiss a performance. But if a number of men come prepared to interrupt the performance by causing a disturbance, it may be rioting, though they may not use any personal violence or cause any injury to the house. where two parties meet without any intention to quarrel, but all of a sudden a fight ensues in which both sides use force. It cannot be said to be a case of rioting in the absence of any evidence to previous concern, which cannot be inferred from the mere fact of joint action, for such action may have been spontaneous and not necessarily the result of previous design. The difference between riot and unlawful assembly. If the parties assemble in a tumultuous manner and actually execute their purpose with violence, it is a riot. But if they merely meet upon a purpose which, if executed, would make them rioters, and having done nothing, they separate without carrying their purpose into effect, it is an unlawful assembly. In short, it is only the use of force that distinguishes rioting from an unlawful assembly. Spectator and wayfarers, etc. Spectators, wayfarers, etc., attracted to the scene of rioting by curiosity, as generally happens in the countryside when a riot or offense is going on, should not, by reason of their mere presence at the scene of rioting, be held to be a member of unlawful assembly or rioters. But of course, if they are proved to have marched with the rioters for a long distance, when the rioters were shouting telltale slogans and pelting stones, it will be for them to prove their innocence under Section 106 of the Evidence Act, that is Section 103 of Bharatiya Sakshya Adhiniyam. In the Raghunath Rai case, several Hindus acting in concert forcibly removed an ox and two cows from the possession of a Mohammedan, not for the purpose of causing wrongful gain to themselves or wrongful loss to the owner of the cattle, but for the purpose of preventing the killing of the cows. They were held guilty of rioting. In Jairam Mahto, the accused and party accompanied with B went armed with lathis to fish in a tank in which B had some share. The complainant, who too had a large share in the tank, went there with some of the co-sharers to protest on the ground the accused had no share in the tank. A fight ensued in the course of which some of the complainant's party received injuries. It was held that the accused were guilty of rioting and voluntarily causing hurt. In a case, some stray cattle were rounded up by an unauthorized spectator. In this regard, the owner stopped him in the way to the cattle pond and demanded immediate release of the cattle. A fight ensued and the inspector's party was hurt. In a charge for rioting and causing grievous hurt, the owner pleaded the right of private defense of property. In this case, the defense will fail because there is no right of private defense against an act of a public servant. In the Udhari query versus Emperor, there was some family dispute between A and B who were relatives. Their houses were adjacent to one another. On 8 March 1936, A and B came to blows over the use of a cattle though and pigs just outside the house of A. The evidence showed that a shouted out, "Help, I am being killed," and on this cry, the other petitioner assembled with lathis. It was held that merely coming to the spot, even with lathis or other weapons, in response to a cry by A that he was being killed, can hardly be considered sufficient to make them guilty of rioting. Further, it was held in the state of UP versus Dancing that when people are killed during a riot, there may be a possibility of the incident being aggravated or some innocent persons being named as being part of the assailant party. This may happen wittingly or unwittingly, but just because there may be some inconsequential contradiction or exaggeration in the testimony of the eyewitnesses that would not be a ground to reject their evidence in its entirety in the case of writing, where there are a large number of assailants and a number of witnesses. It is but natural that the testimony of the witnesses may not be identical. What has to be seen is whether the basic feature of the occurrence have been similarly viewed and are described by the witnesses in a manner which tell the outcome of the riot. Visible, the injuries sustained by the victims and the number of people who were attacked and killed. The Supreme Court in Budhwa versus State held that the conviction of 4 accused out of total of 15 on the ground that there was sufficient evidence and of actual army of their members. Therefore, they were rightly convicted of the offense under Section 146 IPC. The Supreme Court in Krishna Mohan Rao versus Public Prosecutor, while elaborating on the point as to how presence of the accused person and their participation in common object should be proved, held that the prosecution must prove that they were definitely members of an unlawful assembly at the time of using the force or violence. Rioting armed with deadly weapons, Section 191 subsection 3. Section 191 subsection 3 provides punishment for an aggravated form of rioting, that is, rioting armed with deadly weapon, and an enhanced punishment is provided for the same under this subsection. In the state of Andhra Pradesh versus Thakidiram Reddy, there was bitter enmity between the two parties. Miscreant, armed with various weapons, trespassed into the house of the deceased at midnight after breaking open the door, and the accused dragged deceased out of the bedroom to front yard and beat him to death. It was held that the above facts clearly indicated the accused persons had formed an unlawful assembly with a common object to commit some offense. In the present case, the common object was to commit murder. In such a case, every member of assembly would be guilty for the offense committed by any other members of the mob in furtherance of the common object, without proof of any overt act committed by him. It was further observed that to ascertain whether a particular person shared the common object of the unlawful assembly is not essential to prove that he committed some illegal overt act or had been guilty of some illegal omission in pursuance of the common object. Once it is demonstrated from all the facts and circumstances of a given case that he had shared the common object of the unlawful assembly, in furtherance of which some offense was committed or he knew was likely to be committed by any other person, he would be guilty of that offense. Undoubtedly, commission of an overt act by such a person would be one of the tests to prove that he shared the common object, but it is not the sole test. In case of Yadav Lohar versus State of Bihar, the Supreme Court held that where it has not been proved that the accused person were armed with deadly weapon and they had committed any overt act, they cannot be convicted under Section 300, read with Section 307 of the Indian Penal Code, and only on the ground that about 50 or 60 persons had gathered at the scene of incident. In another case, Vajrapu Sambhaiya Naidu versus State of Andhra Pradesh, it was held that accused killed the deceased in order to take forcible possession of land. But the evidence on record showed that it were the accused themselves who were in possession of the land, and when they were attacked by the prosecutrix, they used force in self-defense of their property. Held, if the court felt that the accused person had exceeded their right of private defense, then the court ought to have identified and punished only those persons who was actually exceeded their right of private defense. Case where plea of right of private defense has been raised, and therefore the accused cannot be convicted and sentenced under Section 148 IPC, that is Section 191 subsection 3 of the Bharatiya Nyaya Samhita. Consequently, all the appellants in the case were acquitted, giving them benefit of doubt. Further, in the state of Uttar Pradesh vs. Subhas, the dying declaration of the deceased Bengali stated that respondent was present along with 7 to 8 other persons and he was the actual perpetrator of assault which resulted in Bengali's death. The prosecution successfully established that Subhas, that is Pappu, the accused at the relevant time was part of the unlawful assembly who caused the death. The Supreme Court held that conviction of the accused, that is respondent under Section 302 read with Section 148 IPC, that is Section 103 subsection 1 and Section 191 subsection 3 of the Bharatiya Nyaya Samhita was not warranted, as the case squarely fell within Section 304 Part 1 read with Section 149 of the Indian Penal Code. Merely because the number of persons charge sheeted and they tried were 3 and 2 of them were acquitted as against the dying declaration, which stated presence of 7 or 8 persons, will not be ground to not to convict the accused under Section 148 IPC, that is Section 191 subsection 3 of the Bharatiya Nyaya Samhita. Therefore, conviction of the accused under Section 304 Part 1 read with Section 190 IPC and sentence of 10 years rigorous imprisonment with Rs 500 fine and under Section 148 IPC for 3 years and rigorous imprisonment with a fine of Rs 500 was upheld, and the court directed the accused should surrender within 4 weeks to undergo remaining sentence. The appeal was to the aforesaid extent. In another case, M. Nageshwar Reddy versus State of Andhra Pradesh and others, the 11 persons were charged with the offence of assault, which resulted in murder, that is under Section 302 read with Section 148 of the Indian Penal Code. Out of these accused, 4 to 11 were acquitted by the trial court and 1 to 3 were found guilty of the offence and were sentenced to life imprisonment under Section 302 IPC, that is Section 103 subsection 1 of the Bharatiya Nyaya Samhita, and for 1 year rigorous imprisonment under Section 191 subsection 3 of the Bharatiya Nyaya Samhita. The appellant pleaded that they were falsely implicated because of the political rivalry and enmity with the deceased. Feeling aggrieved, the 3 accused appealed before the High Court, which acquitted them, dismissing the petition of the complainant who had challenged the acquittal of accused 4 to 11. The Supreme Court held that the High Court had committed grave error in reversing the judgment of the trial court, which had convicted accused 1 to 3. Therefore, their acquittal order is quashed and set aside, and the order of trial court is restored, which had sentenced the accused appellant to imprisonment for life. Section 192, that provides wantonly giving provocation with intent to cause riot. If rioting be committed, if not committed, both the circumstances, whoever malignantly or wantonly by doing anything which is illegal gives a provocation to any person intending or knowing it to be likely that such provocation will cause the offence of rioting to be committed, shall, if the offence of rioting be committed in consequence of such provocation, be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. And if the offence of rioting be not committed, with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Section 192 of the Bharatiya Nyaya Samhita corresponds to Section 153 of the IPC. Section 192 of the Bharatiya Nyaya Samhita is having the following ingredients, that is, the accused did an act which was illegal. He caused provocation by such illegal act. He did the act malignantly or wantonly. He did the act intending or knowing it to be likely that such provocation may cause a riot to be committed. Such riot was committed in consequence of such provocation. Malignantly means maliciously. Malignant means virulent enmity. Therefore, malignantly means in a manner virulently and inimical. It implies disposition bent on evil or an unlawful act done intentionally without just cause or excuse. It means extreme malevolence or violently hostile or harmful. Wantonly means recklessly, thoughtlessly, without regard for light or consequences. It implies a reckless or mischievous disposition. A man may do a thing wantonly when he has no reason to do it, but he does it because he takes pleasure in doing, though he knows that its consequence to others may be serious. In Indra Singh, the accused unfastened the strings of a national flag after flag hoisting ceremony and tried to trample on it. It was held that the accused was guilty under this section as the act of the accused was deliberately insulting to the flag and thereby the accused intended to wound the feeling and sentiments of the other persons present. In another case, Abdullah, the accused sacrificed a cow in an open place exposed to the view of the public. It was an act done recklessly or thoughtlessly without regard to the sentiment of those who do not approve of such an act. It is no doubt a wanton act, but it is not an offense under this section because such killing cannot be held to be illegal in the absence of any provision of law which prohibits the killing of a cow. In another case, Vinod Hansraj Goyal versus the state of Maharashtra, the allegation against the author of the book was that one passage from his book had hurt sentiments of people. It was found that author was a serious and intense scholar and book was found by him worth dedication to his mother. It was held that in order to justify conviction under section 153 and 153A of the Indian Penal Code, section 192 and 196 of the Bharatiya Nyaya Sanhita, intention to cause disorder or incite people to violence and creating disharmony in society is the sine qua non. Therefore, in view of facts of the case, the author, printer, and publisher of book cannot be proceeded for offence under section 153 and 153 of the Indian Penal Code. Section 193 of the Bharatiya Nyaya Sanhita that provides liability of owner, occupier, etc. of land on which an unlawful assembly or riot take place. Subsection 1 provides whoever any unlawful assembly or riot take place. Subsection 1 of section 193 provides whenever any unlawful assembly or riot take place, the owner or occupier of the land upon which such unlawful assembly is held or such riot is committed, and any person having or claiming an interest in such land shall be punishable with fine not exceeding 1000 rupees. If he or his agent or manager, knowing that such offence is being or has been committed or having reason to believe it is likely to be committed, do not give the earliest notice thereof in his or their power to the officer in charge at the nearest police station, and do not, in the case of this or their having reason to believe that it was about to be committed, use all lawful means in his or their power to prevent it, and in the event of its taking place, do not use all lawful means in his or their power to disperse or suppress the riot or unlawful assembly. Subsection 2 provides Whenever a riot is committed for the benefit or on behalf of any person who is the owner or occupier of any land respecting which such riot take place, or who claims any interest in such land, or in the subject of any dispute which gave rise to the riot, or who has accepted or derived any benefit therefrom, such person shall be punishable with fine. If he or his agent or manager, having reason to believe that such riot was likely to be committed, or that the unlawful assembly by which such riot was committed was likely to be held, shall not respectively use all lawful means in his or their power to prevent such assembly or riot from taking place and for suppressing and dispersing the same. Subsection 3 provides, whenever a riot is committed for the benefit or on behalf of any person who is the owner or occupier of any land respecting which such riot take place, or who claims any interest in such land, or in the subject of any dispute which gave rise to the riot, or who has accepted or derived any benefit therefrom, the agent, manager of such person shall be punishable with fine if such agent or manager, having reason to believe that such riot was likely to be committed, or that the unlawful assembly by which such riot was committed was likely to be held, shall not use all lawful means in his power to prevent such riot or assembly from taking place and for suppressing and dispersing the same. Section 193, subsection 1 is an extension of the doctrine of respondent superior to criminal law. It makes the master criminally liable for the act or omission of his servant in certain cases. The liability of the owner or occupier of the land does not depend upon his knowledge of the riot or the acts of intention of his agent. They have been invested by law with certain duties of the police, which they are expected to discharge by virtue of their position as landholders. Their responsibility is declared that as a landholders they possess the power of preventing the gathering of men upon their land and to suppress or disperse disorderly gathering if they are so minded. Three classes of persons are responsible under this section. Number one is owner, second occupier, and third person having or claiming an interest in land upon which an unlawful assembly or riot take place. Under section 193 subsection 1, the owner of the land is punishable if a riot or unlawful assembly take place on his land. Section 193 subsection 2 refers to the commission of riot only and not unlawful assembly. When riot take place in the interest of the owner or any person claiming interest in the land. Section 193 subsection 2 applies. Provisions for heavier punishment has been made under section 193 subsection 2 because riot not only take place on one's land but it takes place in his interest also. An offence under section 193 subsection 2 is not complete unless the riot is actually committed. Section 193 subsection 3 makes punishable the agent or manager of the owner or the occupier of land for any offence for which such owner or occupier shall be liable under section 193 subsection 1 and section 193 subsection 2 of this Samhita. However, the agent or manager shall be liable only when he has failed to use all lawful means in his power to prevent such riot or assembly from taking place and for suppressing and dispersing the same.